on 7 bills. These include the Federal High Court Act and the Franchise Regulation Amendment Bills.
Senate is reaffirming its commitment to law reforms that will meet global standards for the benefit of all. President of the Senate Ahmad Lawan said this in a message to a one-day public hearing on 7 bills bordering on judiciary, human rights and legal matters.
There is no gainsaying the fact that one form for collaborating and synergizing with stakeholders in handling legislative proposals and measures geared towards the social act. The 9th Senate, in line with its legislative agenda, resolved since the inception of this current dispensation to conduct public hearings on bills and motions before legislative intervention measures are put in place. This is in view of the fact that laws are made for the attainment of the well-being of the people and to meet their yearnings and aspirations. As such, every stakeholder should be carried along in the enactment of legislation that can be seen as people-oriented. This, in fact, is the beauty in the art of lawmaking in a democratic government and is one of the ways that our legislations can stand the test of. In order to avail stakeholders the needed platform to deliberate and brainstorm on the proposed bills with a view to further enriching for the laws to have all-inclusive to lump these 7 bills together in one public hearing in view of their strategic import. Without further ado, I crave your indulgence to briefly comment on the intendment of the bills under consideration as 2015 repeal and reenactment Emmanuel, representing Benue Northwest Senatorial District and who is also the vice chairman of our committee. The bill, among other things, seeks to repeal the Administration of Criminal Justice Act 2015 and enact the Administration of Criminal Justice for the Administration of Criminal Justice System with a speedy dispensation and interest of suspects as obtained and the London Criminal Justice Board. This is with a view to delivering a fair, efficient, and effective criminal justice. Secondly, the Federal High Court Act, Cap F134, Laws of the Federation of Nigeria 2004, Amendment Bill 2022. This bill was sponsored by distinguished Senator Mukail A. Abiru, representing Lagos East Senatorial District, and who is also the chairman of the Senate Committee on Industry, in the Principal Act, and made provisions for the regulation of the award of pre-judgment interest to ensure the attainment of substantial justice in relation to claims bordering on commercial transactions. A plaintiff against a defendant holding monies either as debt or other obligation to his act in view of the fact that the real economic value of interest would have been lost as at the time of judgment, given the high inflationary rates the country is currently confronted with. 29 Cap F28 Laws of the Federation of Nigeria 2004, Repeal and Reenactment Bill 2022. This bill was sponsored by distinguished Senator Sani Muhammad Musa, representing Niger East Senatorial District. The bill, essentially F28 Laws of the Federation of Nigeria 2004, and enact the Firearms Control Act 2022, providing for the removal of those firearms involving the use of firearms. The intent of this bill is act in view of the proliferation of illegal firearms, which has posed a great security threat in the country in recent time. Therefore, it is imperative for in line with modern realities, to handle the ugly menace. Fourthly, the Violence Against Persons Prohibition Act 2015, Repeal and Enactment Bill 2022, East Senatorial District. The bill 2015 maximum protection and effective remedies for victims of violence in all ramifications. This is with a view to eliminating all forms of violence in both public and private spheres in the country, again to bring its provisions in line with current realities, such as review of imprisonment terms and fines, introduction of adequate compensation for victims of violence, including the establishment of Victims Support Fund, etc., and to generally conform to normative drafting standards for effective dispensation of justice with respect to the subject Regulation Bill 2022. This bill, again, was sponsored by distinguished Senator franchising and to guide the relationship between franchisors and franchisees, and for matters connected therewith. Certainly, franchise is a well-known business concept, whereby a franchisor and trade market. Without doubt, the intent of this proposed legislature is apt as the importance of this viable sector of our economy is not properly regulated through legislation, thereby leading to frustration of franchisees in the country. Accordingly, there is need to have this legislative framework in place. Number 6, the African Union Convention on the Protection and Assistance of Internally Displaced Persons, Domestication and Enforcement Bill 2022. This bill was sponsored by distinguished Senator Frank Ibezim, domesticate the provisions of the campaign and ratified in April 2022. The domestication being sought by this bill is in line with the provisions of which requires should first be domesticated by an act of the National Assembly. As such, the introduction of this bill at this point in time is not unconnected with the incessant incidences of internally displaced persons across the country, arising from insurgency, banditry, and other communal crises, which is expedient that the relevant legislative measures are put in place to ensure that the welfare, rehabilitation, and reintegration of best practices and care for victims of gunshots Act 2017, Amendment Bill 2021, SB 748, and tertiary. This is a joint referral between this committee and the Committee on Health. The bill was sponsored by distinguished Senator Oluremi Tinubu, treatment and care for victims to expand the scope of the Extant Act by establishing Medical Emergencies Assistance Fund and for related matters, set to enforce treatment for victims of gunshot injuries, which were refused treatment hitherto, consequent upon the misinterpretation of Section 4 of the Robbery and Firearms Special Provisions Act. In conclusion, ladies and gentlemen, under the quintessential leadership of His Excellency, Senator Ahmad Ibrahim Lawa, PhD, CON, the President of the Senate, toward the reform of the legislative proposals in the country for the enhancement of quick dispensation of justice. In this regard, we are ready to carry all stakeholders along in the legislative process reasoning that we are all to feel free and make your to the Senate.
The Senate President, distinguished Senator Ahmad Ibrahim Lawan, PhD, CON, for this public hearing. Mr. Chairman, distinguished colleagues, distinguished guests, ladies and gentlemen, to consider 7 crucial legal matters following the resolution at the level of its relevant committee. The 7 bills are the Administration of Criminal Justice Act 2015, the Federal High Court Act, Firearms Act, Vision Act 2015, and the Franchise Regulation Bill 2022. The rest are the African Union Convention on Protection and Assistance of Internally Displaced Persons, Domestication and Care of Victims of Gunshots, that the bills are being proposed as no bills are being put forward for amendment, which suggests the strengthening of this is that the legislature is once more working to improve the legal institutions, the role of the legislature as the source of regulatory initiative before consideration and interpretation of all the arms of government. Our participation today is an invitation to be part of legal institutions building process as qualified stakeholders through meaningful inputs. This is a core legislative procedure that underscores the Senate Committee on Judiciary, Human Rights, and Legal Matters has prepared well for this event, and my charge to us all is to take advantage of this and make robust contributions to future generations. It also falls in line with our innate drive to live lasting in our requisite experiences. While you should be rest assured that the committee will be respectful of your ideas, we are always inclined. I am therefore pleased to welcome you all on behalf of the Senate President and declare this public hearing open. God bless you all. God bless the Federal Republic of Nigeria.
This bill seeks to amend the Federal High Court Act to cure the shortcomings that is inherent in the prelude to such a prejudgment instant. As we are all aware, in Nigeria today, there is no statutory law which regulates the award of prejudgment interest. Nigerian courts, up till date, still have recourse to the English common law practice as a guide in the award of prejudgment interest. And as evidenced by majority of decided cases in Nigeria, in most of those cases where the claims of the claimants on the principal debts were successful, their claims on prejudgment interests were denied. And unfortunately, because the claims did not pass the common law test. So therefore, a legislation and legal framework is desirable to deal with the glaring shortcomings in the law and practice on award of prejudgment interest. And this is the reason why I have come up with this bill. Please endeavor to make your inputs and contributions to so that it captures the essence of what we hope to achieve for the good of everyone. I wish everyone a fruitful deliberations. Thank you very much for your attention.
IDPs are people who have been forced to flee their homes as a result of human or natural disasters and have not crossed an internationally recognized state border. They differ from refugees in that they are not displaced beyond the boundaries of their countries of origin. In Nigeria, for the last 2 decades, the number of IDPs increased astronomically due to the armed conflicts insurgents in the Northeast, farmers-herders clashes, due to large-scale development projects, generalized violence of political or religious nature, human rights violations, flood and other natural disasters, human-made disasters, etc. The increased number of IDPs on the continent of Africa necessitated the adoption of the African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa on the 23rd of October 2009 under the auspices of African Union. The AU Convention for the Protection and Assistance of Internally Displaced Persons in Africa, Domestication and Enforcement Bill 2021 is the product of the Kampala Convention, which the Federal Government of Nigeria ratified on the 17th April 2012. The provision of Section 12 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, requires that treaties signed between Nigeria and other countries or international bodies should be first domesticated by an act of the National Assembly, hence this instant bill. From the foregoing, therefore, the primary motivation behind this bill is to put in place an ideal legal framework and mechanism for addressing core IDP issues in the country. The domestication of the Kampala Convention will pave way for a paradigm shift from relief and humanitarian assistance to IDPs, which appears to be the focus of most IDP interventions in Nigeria, to other germane issues such as prevention, production, rehabilitation, reintegration, and resettlement of survivors, reconstruction of damaged structure, and environmental remediation. It is sad to note that most victims of displacements are left to their fate after the relief phase or even without basic relief assistance. Mr. President, distinguished colleagues, it is indeed worthy of note that the National Emergency Relief Management Agency, NEMA, the National Commission for Refugees and the IDP, and other state emergency relief management agencies are first responders to natural or man-made disaster sites in Nigeria. Apart from the IDPs in the states in the northeast geopolitical zone of Nigeria that are benefiting from past relief aspects of IDP courtesy of the Northeast Development Commission, millions of IDPs outside the northeastern part of the country who have been displaced by endless herdsmen farmers clashes, large-scale project situations, land disputes are still without a holistic interventions in terms of rehabilitation and resettlements, which is the fundamental aim behind seeking for the domestication of the Kampala Convention. Indeed, there is no one here present who is not facing IDP crisis in his constituency as a result of the peculiar challenges we are facing in the country. It is in view of the foregoing explanations that I urge you all to support the speedy passage of this bill.
Once again, it's my singular honor and privilege to be invited to this public hearing and to give a synopsis of the Franchise Regulation Bill 2022. The bill seeks to create a framework for the regulation of franchising and to guide the relationship between franchisors and franchisees and for matters connected therewith. And the objectives of the bill are: 1, regulate and guide the relationship between franchisors and franchisees by imposing certain obligations and prohibiting certain actions. Also, it is to promote the growth of franchising through the adoption of international best practices that balance the interests of franchisors and the franchisee. As we are all aware, we have mass opportunities. This presents mass opportunities for our unemployed citizens, and it therefore seeks, it creates the time, and I think the time is right for reputable foreign franchisors with solid brands to start expanding their operations in Nigeria, as well as for local established businesses to embark on the franchise journey. This is part of our efforts to enhance economic development of our great nation that has informed the passage of this franchise bill, which basically seeks to create a framework for the regulation of franchising and to guide the relationship between franchisors and franchisees and for related matters. Ladies and gentlemen, as important stakeholders who have more specialized information and experience in this sector, I urge you all to avail this committee with the benefit of your expert position, views, and input so that a robust legal framework is put in place to regulate this very important emerging business strategy. I wish you all a fruitful deliberations. Thank you very much.
To start with, I want to
quickly say that I adopt everything that has been provided in this document as the position of the Nigerian Army in respect of all the bills before this honorable committee. And a copy of it has been submitted to the nominated secretariat for input. So without much ado, sir, the first bill, that is the Administration of Criminal Justice Act, I want to draw the attention of this honorable committee that it is not applicable to members of the armed forces. Section 2 of that act clearly states that it's not applicable to us. I don't want to take much of the time. The most important one that really affects us is the one that has to do with firearms. I can see Firearms Act here, number 32, 1959, Cap F28, LFN 2004, Repeal and Reenactment Bill 2022. But what we were given was Firearms Control Act, Repeal and Reenactment Bill 2022. That was what was presented to the Nigerian Army to work on. So the next one is the African Union Convention on the protection and assistance of internally displaced persons, Domestication and Enforcement Bill 2021. My Lord, sir, as the sponsor of the bill rightly pointed out, Section 12 of the 1999 Constitution clearly made for the domestication of treaties and other conventions that Nigeria is a signatory to. Sir, taking a look at thoroughly what is happening in the Northeast, particularly where we have a lot of IDPs as a result of the crisis there. So the Nigerian Army came up with its position in support of the bill and came up with relevant instances, particularly the instance where the Nigerian Army will form part of the implementation committee of that particular bill for the welfare and well-being of the IDPs. I don't want to take much time on that. We have already submitted our paper on that issue. Finally, regarding the compulsory treatment and care for victims of gunshot act 2017 as amended bill 2021, the Nigerian Army equally stated clearly that the compulsory treatment and care of victims of gunshot act bill seeks to amend and expand the scope established in medical emergency assistance fund align punishment contained therein with the current realities for related matters. The bill is divided into. So I think the Nigerian Army's position is very clear on that particular bill, and I think it's a very good step taken to amend the bill, because I just have a short story to tell. That is my own personal experience that has to do with this particular bill. Sometimes in 2014, while I was serving in Owerri, I was the legal officer of 34 Brigade, and at the same time, I was the sector commander for internal security, so covering Owerri North, Owerri West zone. So while I was away for a short assignment, one of the soldiers under me mistakenly shot a civilian. And the civilian was rushed to the Owerri Federal Medical Center. I was called and informed about the issue. Immediately I left what I was doing, I went there. In fact, to cut the long story short, I found myself virtually treating that man, paid his hospital bills, everything and the rest. Since then to date, I paid everything because I know why I felt his pains. I didn't even want to wait for any bureaucracy or any procedure because I don't know what will happen. I want to save a life first. Personally, I was the one that put in the bills, everything. I did everything for him before later on it was taken care of, other things were taken care of due to procedures. I want to thank this committee for this opportunity given to us to deliberate on the bill. Like I said, I don't want to waste more time because we've already put pen to paper in respect of the whatever we have to say. Thank you very much.
Specifically making comment on behalf of the sponsor of the bill for an act to amend the compulsory treatment and care for victims of gunshot 2021 to expand the scope, establish a medical emergency assistance fund and align punishment contained therein with current realities and for related matters. The bill is being sponsored by Senator Oluremi Tinubu. As Chairman of the Senate Committee on Health, we've had the opportunity of looking at this bill. And what we are trying to do is to align the bill with the two other laws. We have the National Health Act that has a provision for treatment of emergencies without recourse to source of fund. But specifically, under that act, there's a provision of 5%, which is to take care of emergency. The challenge with it was because there's another law when NCDC was established, which gave NCDC to benefit from that 5%. But through the regulations that be harmonized to share the 5% between NCDC for public health emergency and another percentage for national health emergency. So the current Senate has already passed the National Health Emergency Act, which is establishing formally national health emergency in the country. So with that fund existing, what this bill is trying to propose, we want to harmonize it to see that we use those two other laws to cure what this bill is attempting to do. Because the national health emergency already is going to draw money from National Health Act 5% of basic healthcare provision fund, as well as additional fund for national health emergency. In fact, in the current 2022 budget, a sum of 1.2 billion was allocated for national health emergency. The pilot has started in Abuja with ambulances and so on. So that will be able to take care of this, Mr. Chairman. And that's the position. So our committee and the committee on judiciary will work to see that we harmonize and synchronize all the laws so that we get the intent of this bill to be effective. Thank you, Mr. Chairman.
Let me start with the bill to make provisions for the regulations of the awards of prejudgment and interest. Before going to the crux of the matter, we should first just observe that the spelling of prejudgment is wrong in the long titles, so that it will not escape the sight of issue. Then number two, the enactment clause started with be it. The position had long been changed. We've changed that. The current practice is simply enacted, so that too should be taken care of. We have seen the objectives of the bill. The sole intent is to make provision for the regulations of what prejudgment and interest. We went through the bill. Initially, it seems to us as if the bill came from the premise that there is no form of regulations of prejudgment interest. We have seen it from that perspective. But we also examined the other way. And when the distinguished senator came in to explain, he gave a good explanation for that, and we quite agree with him. There are regulations, forms of regulations littered in different decided authorities, regulating what? Prejudgment and interest. But it is not captured in the Federal High Court Act, the relevant provision which the bill is seeking to amend. So initially we looked at it and felt that it exists in Nigeria. Do we need to support this bill when we have it already in existence? Will that not amount to a surplusage or a duplication? But on a further reason, and that would have tempted us possibly to oppose the bill. But on a further consideration, we said, look, it is better if we allow it to come into the bill to form a statutory regulation to work alongside with the case law regulations. So for that reason, we decided to support the bill. We cited the case of Hausa and First Bank that has taken care of that, which recognized the existence of pre-judgment and post-judgment interest. This section 2 goes further to decide to elaborate on the procedures of regulations, the circumstances under which pre-judgment interest can be granted in Nigeria. That one, there must be an agreement between the plaintiff and the defendant. The plaintiff must first claim pre-judgment interest, and he must also prove it to be entitled to it. These are the general positions anyway in law. The court is not the Father Christmas to grant that which you did not claim. So we looked at it and therefore decided to propose an amendment of that second provisions of the bill. Because if you read it as it stands, it means as if the court is compel, because it reads the court in the exercise of the jurisdiction shall, meaning it shall be compelled. But we know that the court cannot be compelled under such circumstances. We should prefer to use the word the court may grant prejudgment interest, because the word may is consistent with one, pleading it, proving it before you become entitled to it. So we support the bill with that modification. We have submitted our memo. You will see it there clearly. Then the second bill is the bill on the Convention for the Protection and Assistance of Internally Displaced Persons in Nigeria. This is another very important bill. We have always indulged in the attitude of going to enter into international conventions and become state parties. But we always feel reluctant and not quickly enough to come and domesticate in line or consistent with Section 2 of our Constitution. So for this purpose, this bill is equally very, very important. But we need to, we commend it. We also need to state that although we, from the justice angle, are aware that there is equally a national policy on this area that the federal government has come up with. Number two, we are equally aware that the Federal Ministry of Humanitarian Affairs, together with the agencies under its supervision, are presently working on the domestication of this bill. Following from this, it is the view that there is need for collaborations of efforts between these agencies and this very committee to ensure that no agency is left out in terms of its contribution to make this bill very robust. We've also observed that there are two procedures through which you can domesticate a convention. You may decide to adopt it entirely and schedule it. You may decide to make some modifications as it is proposed here. Because we've seen here that there is a proposal here on, there's a proposal by some agencies on several things that need to be included in that bill based on what we have come across. And as this bill is good, we observe that there are some areas that are not adequately covered in this bill. We call it non-inclusion of responsibility and rules of some of the agencies. And here, you may read, you say, there are areas that are not adequately covered in the bill as intended by the convention, such as providing responsibilities and roles of armed groups, non-state actors, and other relevant actors, including civil society organizations, with respect to the prevention of internally displaced persons. So it is our suggestion that this good is good. While they are working on it, there is need to invite for further collaboration from the agencies interested in the area. Then the third bill is compulsory treatment and care for victims of gunshots. I was privileged to know when this issue was coming, even that led to the enactment of the act. Basically, it was first dependent upon an article written by Professor Idu of Faculty of Law, Bafemia University on this issue. And I was happy when the National Assembly passed this bill into law. Because we've seen so many people, Nigerians, have lost their lives because of this. You go to the hospital, they refuse to treat you, not wanting to know what may have caused the gunshot. Perhaps the person that was shot was fired innocently and you refuse to treat him, then he dies. In the legal profession, I remember when we were still young lawyers, we go to court and they bring an accused person. They read the charge and you discover that there's no lawyer for the accused person. First, you feel that maybe he has no money to secure the assistance of the law. You get up even without being consulted immediately. What is your primary intention at that time? Is to ensure that you file for the release of that person on bail. Let him go out free and stay out there to begin to plan, get the services of whoever he feels he can defend him. So you can see then, can you compare that with the situation of life of somebody? He has been fired and is almost dying, and you refuse to treat as a medical doctor. For what reason? So this bill is another very, very important bill that we also would like to share our views with. But our concern on that bill is the establishment of the Medical Emergency Assistance Fund, which will have you can see the executive, the governing board, then you establish the secretariat. All this will require funding. If you look at it, it's just like an agency established in disguise. That is how I see it and how we see it. And the government may be a bit reluctant, perhaps, following the present policy thrust of the government of not wanting to duplicate agencies or cut the cost of governance. We do not want to participate in a situation where we discover that a bill which we so cherish was not assented to. So it is our belief that while this bill is good, this area dealing with this medical emergency and this should be expunged and modified in a way to make the bill suitable and acceptable to even the government and this other side of the divide. So that's it. The fourth part is a bill for an act to create framework for the regulation of the franchisors and franchising business. We all know what is franchising. It will help to boost our economic development in the country and so on. It will enable us to get so many things that we do not have now and so on. We can learn a lot from them. So conclusively, on victims of offensive violence offenses, we have also made there are a lot of typographical errors which we have identified and proposed for corrections.
Sir, we have articulated our comments in the papers which were submitted to the secretariat of this committee. We made the comments on 3 bills: the Criminal Justice Act of 2015 repeal and enactment bill 2022, Violence Against Persons Prohibition Act 2015, Compulsory Treatment and Care for Victims of Gunshots Act. I may not speak to all of them, but permit me to speak to the Additional Criminal Justice Repeal and Reenactment Bill of 2022, which is of utmost concern to us. We have made some comments in the matrix which we have submitted. But first of all, I want to talk about the provision which seeks to establish the Additional Criminal Justice Monitoring Council. And our position is that that is quite unnecessary to use a procedural law to set up an agency of that nature, which has a juristic personality and has the capacity, is empowered to establish offices in different parts of the country with an executive secretary and other people who have tenured appointments in a procedural law. I was of the opinion that is quite unnecessary. That it should be left the way it is in the extant law. The Criminal Justice Monitoring Committee, they are already doing a good job. So that provision is, to our mind, unnecessary. And then we have also their other provisions. Principally, we support the bill, and our position is that some of the concerns which we have raised be addressed. One of the positive and commendable provisions in the bill is the requirement for a presiding judge to make comments in a case that he is doing. In case he is elevated or he retires, another person can take over from there, because we have had series of undue delays in the disposal of cases by reason of elevation of judges, retirement, or even death. So if we have that provision which will enable an incoming judge to take over from where the person who was presiding on it has stopped, with side comments to deal with the issue of demeanor, that will help a lot in speedy disposal of cases and dispensation of justice. So we also looked at another provision that requires the Attorney General of the Federation to call for case files from law enforcement agencies. We felt that provision needs to be properly balanced. The Attorney General has constitutional powers to initiate, continue, discontinue, or take over any proceedings, and no person can go against that. But taking into consideration the fact that Attorney General is also a Minister of Justice, a political appointee, that provision is liable to abuse. So may be used for political patronage. So it's like this, very important that that be properly reviewed. So these are what the other comments are in our bill. So we support that Criminal Justice Amendment Bill, the Violence Against Persons Provision Act, and we also support it. We have made our comments and we seek that they will be addressed. And then the compulsory treatment on gunshot victims. We also support that bill and we have made some comments. So on the whole, we just want to thank this committee for this opportunity. Thank you, sir.
I'm only going to comment on the Administration of Criminal Justice Act, Repeal and Reenactment Act, because about the other bills, the numbers 2 to 7, we are in support and we have made no comments. And we have not submitted any position paper because before the EFCC submitted their papers, but that court to review it together. And I will totally align ourselves with all the comments they have made. Because we went through it together, and when they submitted, I felt there was no need for us to duplicate whatever they have done. So I'm totally in support. And there's another section which he didn't mention on the section. We have asked for the repeal of sections 355 and 359 of the proposed bill that gives a complainant power to withdraw cases when the case are already in court. We have had instances where maybe we're prosecuting somebody, then for a criminal offense, the petitioner or whatever is settled, and then they come to court to say we are no longer interested in the case. And by virtue of those sections, most of those cases are struck out. So we have asked for the removal of those two sections. And that's our comment, and we align ourselves completely with the EFCC.
I'll start with the first one in my paper is on the Federal High Court. Now, it is a welcome development, but what we have seen is that the bill seeks to amend Section 11 of the Federal High Court, and the arguments are there. It's Section 11 that it seeks to amend. And that Section 11, sub 1, says that existing Federal High Court, particularly from the portion that reads, all such remedies. So if we say all such remedies, and then which can be interpreted in the court and argued by judges and lawyers and all that, in that regard. But it is just an explanation, further explanation of that Section 11.1. Well, there's some editing there, very simple. Instead of the word prejudgment, you say prejudgment, and so on and so forth. Now the next one, on violence. The bill is also a welcome development. The bill seeks to repeal the Violence Act, Persons Act. Now, there is this argument that clause 29, 1 and 2, the use of high court should be clearly defined as in clause 28 for consistency and clarity, since high court is not defined in the act as the word court. So if you look at the word definition of court, and then you say high court, and then you say federal high court, you see, we have to be very consistent in the act, in the law, so that it can convey exactly which court you have in mind. Then the other one, the rest of the comments are there. Then the other one, which is on victims of gunshots. The victim of gunshots, what the representative of Attorney General said concerning the fund. Well, the Commission is of the view that there need to be clarity on how the fund will be implemented in practical terms. It is very silent. He just like, he said something, I don't want to repeat what he said. So, the bill is silent on how the fund will be accessed or disbursed to who the bill is meant for. It does not clearly state how, and so on. So access to the fund for the emergencies need to be, the explanation is there on that, yes, how do you access it, when and how, in what way, okay, in what ways. Then the other one, the other one is on franchise. It is a welcome development. is a replica of Malaysian law. It is believed that if the law is passed in Nigeria, it will bring about positive results in the economy as it is going to be, as it is done in other climes. But there are some editing issues there. The bill did not provide for a short title or citation section. The long title should be rephrased to state that a bill for an act to regulate, for example. Then clause 21 should be renumbered correctly by inserting subclause 1 in the first paragraph, since it has a subparagraph 2. So these are just minor things. So I don't want to waste your time, so you can read through the details in my submission. Thank you, sir.
The bill on the administration of criminal justice, we have quite some concerns. In respect of section 34(4), we think there should be a time frame when a request to the Office of the Attorney General should be made, and a response, we think 48 hours should be okay. Under section 103B, we think there is a need for a time limit also within which to transfer a case where the cause of complaint arose out of jurisdiction. Under section 113(7), we think that which deals with requests by an HRC of returns from the Chief Judge, we think there should also be a time frame. If we make that request, we think 48 hours should be also okay. We think under section 234, where the judge can try some cases in secrecy, we don't think cases of economic and financial crimes should be included among the cases that can be tried in secrecy. It is okay if we try justify cases of terrorism and trafficking in persons, but we don't think economic and financial crimes should be there. Section 406, which prescribes punishment of death by hanging or lethal injection. Of course, we in human rights don't think that the death penalty should be sustained. We think that life imprisonment should be okay in that case. Anyway, in Nigeria, there are hardly execution of death sentences, and after the report of the National Study Group on death penalty, officially Nigeria has placed a moratorium on execution of death sentences. So I think our laws should start being in sync with that position of Nigeria, so that we don't continue to increase number of incidents where we have capital punishment. We think life imprisonment is okay for that. Looking at the Violence Against Persons Prohibition Act, we think that the sections 1, 2A, 3, 4, and 5, which talk about where offender is less than 14 years of age, the offender is liable to a maximum of 7 years. This conflicts with the Child Justice Administration principle in the Child Rights Act, which says that no child shall be subjected to criminal justice process or to a criminal sanction, but a child alleged to have committed an act which would constitute a criminal offense if he were an adult shall be subjected only to child justice system and processes set out in that act. So we think we should look at it again. Then section 17(1) of the bill talked about a person who abandons a wife or husband or other dependent without any means of sustenance commits an offense. We think there are circumstances under which a wife or a husband can abandon, because if the person is under threat, threat to your life, the first law of nature is to try to protect yourself. And in that case, in the case of Musu and Wusu, Court of Appeal, Owerri 127/2009, the Court of Appeal upheld a mother's right to remove herself and her children from the matrimonial home in the event of threat or fear of violence. So I think we should put that into consideration to grant an exemption, because it should be a defense if somebody's life is threatened and he decides to abandon the wife or the husband. In the case of the Firearms Act, of course, is a welcome development. We in total agree with the provisions, which also goes to further strengthen Nigeria's position on the domestication of the Convention Against Torture, because if somebody is suffering under gunshot wound and you don't afford the person medical attention in time, it could further compound torture. And Nigeria has already domesticated the Convention Against Torture. So we think that this act is in line with our position. Then the good one about the domestication of the convention, the Kampala Convention, we think this is a very wonderful initiative by the committee. We don't think we should wait for any stakeholders who can stay for another 10 years for the domestication of a Kampala Convention. The issue of IDPs in this country has reached a crisis stage, so it has reached a situation of national emergency. So this is a very welcome development, and we'll support it in total in line with the Section 12 of our Constitution. We have pointed out a couple of issues which are mainly typographical, and we have submitted that, and we hope the committee will look at that, especially in the areas of prevention of displacement, protection from displacement, and offenses relating to displacement. The other act is the act relating to, well, I've talked about the victims of gunshot wound. The other act is the one on franchisors and franchisees, which we also welcome. We support it in total, and we note with particular reference to Section 4 of that act and Section 13, we talk about freedom of association, and as well as acknowledge the right to non-discrimination, so which we think are very important human rights principles that act seems to uphold. So we have made copious comments, and we have submitted that to the committee, and we hope the committee will be able to look at it. Thank you very much.
I wish to commend or to thank this committee for conducting this public hearing, notwithstanding your extremely busy and tight schedule, and particularly for listing these very important bills. And before now, we have consulted with various stakeholders on, some of these bills, particularly the Administration of Criminal Justice Act. And I can say that we are working towards a consensus. By the end of this committee, by the end of this sitting, we intend to go back and review the bill based on the suggestions that have been made by the various stakeholders. So we thank the committee for providing this leadership. The only other comment I'd like to make, sir, is with respect to the franchise regulation bill. I want to humbly suggest that the committee should consider removing the word regulation so as not to cause to avoid any confusion, because there's a power within the bill giving the executive some power to make some regulation. So if we call this franchise regulation bill, the regulations that may be made pursuant to this bill, may be confused with the act itself. Perhaps the committee in its wisdom may want to consider dropping the word regulation, so we'll simply have franchise act, which would, I've already discussed that point with the legal drafting department of the Ministry of Justice. I do hope that this will be given some consideration. On that note, we'll continue to work with the committee to ensure that we get the best outcomes from the various bills. I thank you for this privilege.
In actual fact, the firearms control has a lot of things to do with us, because we are mandated to be carrying firearms. And as a result of this, the regulations and the control of the firearms is very necessary, and we are very grateful that this is being done, so that, because we all know the security of the country today, and we are all aware of what is going on. So we need to control this, and we are aware that we have a committee that is on small arms control with the National Security Advisor. We are a member of that group. Secondly, the Franchise Regulation Act as suggested. We are very happy with this because we have a lot of our facilities that have been franchised out, that we have a lot of partners that are working with us. We want a way where we can have regulations that we bind us and we bind them, so that at the end of the day, we can do a very good job for the benefit of the country. And again, in all others, administration of criminal justice, most of them, we are all aware of what is going on. The African Convention for the Protection and Assistance of Internally Displaced Persons, we have officers in all the local governments, and we have to deal with a lot of both Nigerians and non-Nigerians. Either you are legally in the country or you are irregular. And as a result of that, a lot of them, especially from across the very close countries we have, like Niger, Cameroon and Co., do filter into this country, and at times they enter into this. This is very good, and we hope that the good job you are doing will continue. Thank you, sir.
The Violence Against Persons Prohibition Act, repeal and enactment. Most of the things we noted have already been highlighted by the previous speakers. However, I will have to stress on just these 2 points. We have like 12 things we've outlined. One is on the long title. We feel it's good to have the long title include the establishment of Victims of Violence Support Fund, in line with the fact that long title is intended to provide a summarized description of the purpose of any instrument. Finally, I will talk on Section 54 on Protection Act, Protection Order, which dealt on protecting people who are being threatened. We know that at times people can be sinister enough not just to target somebody, but they can target your loved ones, your child, your spouse, or however. So if this is captured, we will appreciate that. We support the bill in total, and my minister, especially my minister, is really happy about the issue of Victim Support Fund being captured in that bill. It's a very welcome development and laudable. Thank you.
FIDA Nigeria has submitted a memo and we adopt same in its entirety. However, our memo is limited to 3 of the bills, being the Violence Against Persons Prohibition Act 2015 Repeal and Enactment Bill, the African Union Convention on the Protection and Assistance of Internally Displaced Persons Domestication and Enforcement Bill, and of course the ACJA Amendment Bill.
Ladies and gentlemen, as you are aware, the Kampala Convention was adopted originally on the 23rd October 2009, and Nigeria ratified the convention in April 2012. And the NCFRMI, in collaboration with the relevant stakeholders, began the process of domesticating the convention through the NCFRMI draft bill, which is currently in National Assembly after a multi-stakeholders amendment was carried out to address gray areas identified. This domestication and enforcement of the Kampala Convention will rather reimpose our NCFRMI bill, which is in its final stage. Kampala Convention is a pioneering instrument, the first legally binding instrument on IDPs. The Kampala Convention reaffirms existing international and regional laws, including human rights, international humanitarian law, and consolidate these standards into a single instrument designed to address the unique characteristics of internally displacement in African countries, while also providing a clearer and stronger legal basis for protection of internally displaced persons. Consequently, the Kampala Convention, in accordance with the guiding principle on internal displacement, covers all causes and phases of internal displacements and expressly commit both state parties and other stakeholders to act to the extent of their capacity to prevent displacements and to assist and protect internally displaced persons throughout their displacement until a durable solution is found. At this point, I want to extend my appreciation to the Senate Committee on Judiciary, Human Rights and Legal Matters for their effort in the process of domesticating the African Union Convention. It is anticipated that the passing of this law as a stand-alone bill will further the achievement of humanitarian assistance and protection to our persons of concern.
We want to express delight, commend this noble Senate for inviting us for this. Particularly, we are particularly interested in the franchise bill. The franchising, as the Honourable Senator, distinguished Senator Abiru said, being a catalyst for the growth of economies in many nations, that has been impeded in Nigeria because of a lot of unfair practices, and that's why we're delighted about this bill that hopefully will checkmate these practices. However, there are two areas that we would like to also just highlight in terms of further input. The first one was articulated by Professor Akija George, Senior Advocate of Nigeria, about the word regulation. And I think it was well articulated that maybe it should just be franchise bill rather than franchise regulation bill, because the agency is supposed to make regulations or further regulations apart from the act itself. And the second one is to propose, as we have now in Kama, is the first time, the new Kama, where BRIPAN, a private organization that's recognized, Nigerian organization, but a member of an international organization, is meant to regulate the practice of receivership. So the same thing with those who are involved in franchising, that we could have an association that works with the government in doing public-private sector promotion of franchising in Nigeria. I want to say that we, our members, local, international, are delighted about this bill, and we urge this National Assembly to expedite action on the passage of the franchise bill. Thank you very much.
We are in practice and we deal a lot with the franchisors and franchisees, and we're talking about trade here. NOTAP primary purpose is acquisition of technology, registration of these technologies, and promotion of these technologies. The skill sets that are necessary in implementing and seeing to the smooth function of the franchise activities in Nigeria, without if NOTAP is that appropriate body. But the representative of NOTAP said something very important, and that is cutting costs. Since NOTAP has a view on it, then maybe it may make sense that NOTAP should actually be the right body for that. If that becomes the remedy that we would have to follow, then we would therefore need to look at the constitution of NOTAP, the persons, the human persons in NOTAP, and see if the bill can perhaps add some other persons who are very, very knowledgeable in trade, so that when those people join NOTAP, then that problem can be solved, and that is our recommendation.
I know we met you here, most of you, and even after you made your presentation, you still waited to hear what other people are going to say. This can only attest to your interests in what we are doing. And the second thing I need to do again is to reassure all of you that what you did here was just to briefly speak to your memoranda. The details of the memoranda would pay attention to them and would do justice to them, because otherwise the essence of this is defeated. Is to ensure that relevant stakeholders are able to make their own valid inputs to the legislative process, and we will do our best in this regard. I want to really thank you once again.
These bills are expected to further strengthen the judicial system.
Also in this package
is the meeting involving principal officers of the Senate and heads of security agencies on Wednesday, the 3rd of August 2022, on ways to improve national security. At the security meeting, which later dissolved into a closed-door session, President of the Senate, Ahmad Lawan, called for a change of strategy in tackling insecurity.
This is a meeting at our instance as body of principal officers of the Senate. And there will be two segments to this meeting. The first segment is this segment, which is an open segment, where we make remarks of general nature why this meeting is holding today. And the second segment is the segment that will be a closed session where our media friends will excuse us and all other non-essential personnel who are here will also have to leave, so that we hold the session that I may term as no hold barred. We invited you today for what is obvious, what is before everyone, what is of concern and of interest to every single Nigerian today. The Senate, before we went to recess, we had discussions over the security situation of the country, but even before them, we've had several discussions over the security situation. Let me say that this Senate particularly had shown serious commitment and partnership with the executive arm of government, and as far as I can remember, there has never been an administration in this country, as far as I can remember, and especially since the Fourth Republic started in 1999, there has never been an administration that invested so much resources in the security of this country like this present administration. I have no doubt about this. I'm a participant. So to a very large extent, I can say that none. We believe that as the National Assembly, we have always met the executive, this executive, at the right position, at the right time, most especially when it concerns investments in the security of life and property in Nigeria. We have also, in our individual capacities and as committees of the National Assembly, and in fact as a National Assembly, shown concern about the security situation. And the security situation of any country cannot be 100% satisfactory. But of course there is a level at which no country can be comfortable with insecurity. Ours has lingered, definitely. We had hoped that by this time the security situation of Nigeria would have been far better, and Nigeria would have made more progress, not only in the area of security, but in the area of our economy, which is tied to the security situation again. I believe that our security agencies and armed forces have been doing their best. The armed forces, I don't know of any country where there's enough, really. But even within the scarcity that we have, this administration and this Senate and National Assembly has always prioritized the security of our country. So this particular section of the interaction between us is to look into where we are today and probably this current present position where we are is most frightening, because it's like there's nowhere to hide or nowhere to go. It's like insecurity is everywhere, and especially if it is coming to the point of dislocating the security situation where the head of government or where the government headquartered. So we really have to review and see what more we have to do and how differently we have to do. Our population is largely peasant. Most of our people are in the rural areas and they lead their lives by going to farms. We all know this. In many parts of the country today, that is a Herculean task. Then this have taken over, but it is our desire, and in fact my belief, that we can do better to secure the rural areas, the so-called ungoverned states, at least for our population who go to farms to earn their living, where our agricultural productivity is drastically going down. That would complicate the security situation, because the most ordinary, everyday Nigerian cares more on an age. So we have to look at that. We have problem with the economy to some extent because of security. No foreign direct investments, or not as much as we would ordinarily attract to our country. The level of oil theft is of industrial scale today, and many of the oil companies, especially the oil majors, the international oil companies, don't feel this environment is secure enough for us to export and earn revenues for the development of our country. So if our crude is stolen at such a high level and high scale, that means our revenues will drastically go between now and end of the year or the first quarter of next year. In fact, our prayer is to start seeing serious and drastic and remarkable our efforts. You had meetings and you might have come up with different strategies to see how the situation can be bettered. On behalf of all my colleagues here, I want to... Oh, okay. Is that fair? Okay. So you are presenting... Okay. To consider other things or other areas or ideas that we didn't have before. But I want to assure you, anything and everything you tell us, please be confident that we are talking to partners who will keep them issues of operational nature, and we think very classified, you may even...
National security must be seen from a collective perspective. To assure you that quite a lot has happened, quite a lot has been done, quite a lot is being done to ensure that we improve on the security setting across the country. The commitment is there, it's very profound. I believe that as we go into the discussions on specifics, it will be clear that no one is leaving any stone unturned in redressing all the imbalances within the security environment. Once again, thank you, Your Excellency. I'm delighted to be here. Thank you, sir.
Thank you very much, CBS.
That's a package on today's episode of the program from the National Assembly. I am Ignatius Nkwo.
I'm actually a passionate baker. I don't rest until everything is done. When I entered university, anytime I'm broke, I'll make cupcakes and go and sell to the other students. Decorating cake is an artistic thing, and art is, dynamic.
Join us on Baker's World every Thursday on the network service on the NTA. Baker's World, celebrating creativity. Don't miss it.
On your TV, computer, iPad, tablet and phone, log on to visiontv.co.uk and click on Entertainment, then NTA. You can also download the iOS or Android app on your mobile devices to watch NTA International on the go, anywhere in the world. NTA International, your window through the
world. From dusk to dawn, 24 hours a day, NTA International is with you. In your living room, office, and everywhere, anywhere. We provide the company you desire in terms of balanced and up-to-date news, programs, and the best of entertainment. Tune in to DSTV channel 251, GoTV channel 91, Freeview channel 264, or live streaming via www.visiontv.co.uk. And to watch NTA International in the USA, Canada, and Mexico, use the following satellite parameters. You can also see us on Facebook and YouTube for quality content on the go. NTA International, Africa's window to the world.
It's a fresh episode of the program. Bon appetit! A culinary adventure with my humble self, Sarah Tuesday, trip to Nigeria. Or you were in Nigeria and looking for something to do. One fun idea or activity you have to include in your itinerary, without a doubt, is to try out the food. As a west, north and south, to virtually every corner in between the country, there are a plethora of spice-rich, flavor East Nigerian savory dishes. Hooray! Take a look at her profile. Nigerian cuisine consists of dishes or food items from the hundreds of ethnic groups that comprise our country. Our foods are colorful and lavish. Like many West African cuisines, known also to be spicy because we use spices and herbs to create deeply flavored sauces and soups. Chef Fatima, we're always glad to have you on set of the program. One of the Culinary, I mentioned, what's the big idea today? Okay, today we're having a Nigerian cuisine from the eastern part of the country. I guess we have a lot of flavors to go with. That is our natural ingredients, our natural flavors. You can see them on the display. And of course, we are having our chicken unkobi today. The usual unkobi people go for is the cow leg unkobi. But today, yes, I'm trying to give it a twist because that is all what food is all about. Getting a nice twist, giving it a touch, and of course, you have to make it innovative. Even if you don't invent, yes, because innovative meaning adding to what has been in existence while trying to keep, of course, natural originality. Yeah, originality is very important. Yeah. Alright, beautiful. I am looking forward to seeing how it unfolds, and I believe the feeling is mutual with my viewer out there. Yeah. So fasten your seatbelts. We're about to begin the gastronomic tour. Let's see. Okay, haven't given you what we have. That is the menu, which is chicken unkobi. We have our agidi, a kind of a fluffy agidi. But if I surprise you, say that fluffy white agidi. We use black pot to make it, but it turns out to be white. That is the African secret. So it has this flavor of the earthen pot. Yes. It's wrapped in the course. No, we don't wrap it in it. We use press. Right. So let's just quickly introduce the recipe itself. That is the ingredients. Yeah, when I say recipe, some persons might be confused.
Stay tuned.
We'll see you later. Adawari Tato, Mr. Peter Elegan, an associate of His Excellency the Government.
And welcome to the commissioning of Rivers State University, Rumeche, Emoha campus. Today's event will also witness the flag of construction of one-story building consisting 6 units of 3-bedroom flats. Oyo State Governor Seyi Makinde will perform the ceremony. On behalf of the outside broadcast crew, I am Jenny Bassi, welcoming you to Rumeche, Emoha local government area of Rivers State.